Inside a courtroom, the atmosphere is hushed, orderly, and bound by centuries of tradition. But outside those doors, the New Zealand public is growing increasingly loud and increasingly angry. There's a widening disconnect between the justice system and the citizens it serves. Across the country, voters are expressing deep frustration that our courts seem to treat violent offenders better than the victims they leave behind. This tension stems from how our legal framework is built. New Zealand operates on a common law system. That means instead of strict, rigid rules, judges have immense flexibility and discretion to shape individual sentences based on the specific circumstances of every single case. That discretion was originally designed to ensure fairness, but to many New Zealanders watching the nightly news, that flexibility has gradually morphed into a culture of excuses, where severe consequences are routinely evaded. To understand why people are so angry, we have to look at a specific mechanism used in our courts: cumulative sentencing discounts. This diagram shows how a starting prison term can be systematically whittled away. Judges can apply a reduction for an early guilty plea, then another discount if the offender shows remorse, then another for a disadvantaged background. Often, these reductions stack together, shrinking a violent offender's actual prison time by more than half. And then there is the way the system treats the victims themselves. During the trial for the murder of British backpacker Grace Millane, the defendant argued that her death was a tragic accident during consensual rough sex. The fatal flaw in this legal strategy is obvious. There were only 2 people in that room, and one of them is dead. With the victim unable to testify, only the killer is left to speak, effectively putting the deceased woman's character on trial. When extreme judicial flexibility allows perpetrators to drastically slash their own sentences or legally blame the people they killed, the justice system creates a vacuum. It abandons the vulnerable people it was built to protect. Blaming the victim to secure a lighter sentence might feel like a modern problem, but it is actually a deeply entrenched historical pattern in our courts. For decades, defense lawyers representing accused rapists would routinely cross-examine victims about their past sexual histories, using their personal lives to cast doubt on their credibility. The public backlash became so intense that Parliament was forced to step in. In 1976, lawmakers wrote strict new rules that severely restricted those intrusive questions, drawing a hard boundary to protect the victim. We saw the same pattern repeat with the law of homicide. Up until 2009, men who killed their wives could use a provocation defense. They would argue in court that they were nagged or taunted to a breaking point, successfully downgrading a murder charge to manslaughter. Look at how the timeline of reform lines up here. Just like the sexual history loophole, the provocation defense caused immense public outrage, and in 2009, lawmakers intervened again, explicitly rewriting the law to abolish the provocation defense entirely. The historical lesson is clear. Whenever the unwritten flexibility of the court fails to protect the vulnerable, society inevitably steps in to write explicit, strict rules. Compare that abolished "she nagged me" defense to the rough sex arguments we see today. The language has changed to "she wanted the violence," but the legal tactic of blaming a silenced victim is exactly the same. And we see this repetition in sentencing too. The historical manipulation of court procedures mirrors the modern frustration over Section 27 cultural reports, which are often used to heavily dilute the prison terms handed down in buildings just like this one. New Zealand is currently caught in the exact same historical cycle we experienced in 1976 and 2009. The immense flexibility of the courts is once again temporarily favoring the perpetrator over the public. But just as society firmly rejected victim blaming in the past, modern New Zealand has reached a breaking point. The community standard has shifted, and the public is demanding an end to modern excuses. That public demand is not subtle. Ever since the overwhelming results of the Norm Withers referendum on victims' rights, there has been a persistent, widespread societal pushback against lenient sentencing. In response to that demand, lawmakers have drafted the 2025 sentencing reforms. Led by Justice Minister Paul Goldsmith, the government is deliberately pulling power away from the judge's bench and putting it into written law on the Parliament floor. This animation illustrates the new hard cap. Instead of allowing cumulative discounts to reduce a penalty by 60%, the law restricts total discounts to 40%. The reforms also add aggravating factors. Exploiting a young person or live streaming an offense requires the court to push sentence severity back up. In legal terms, this process is called codification. It takes the guesswork out of judicial discretion and locks the community's standards into strict written law. This marks a clear evolutionary journey for New Zealand justice. We are moving from a system where victims could be silenced and their characters traduced, to a system where the law explicitly draws boundaries to defend them. By firmly limiting discounts and capping excuses that can be used in a courtroom, the country is officially closing the legal loopholes of the past. This is a structural correction. It pulls the pendulum back from limitless judicial flexibility, establishing concrete limits on what the courts will tolerate. The law is finally aligning with modern expectations. It is establishing a baseline standard that prioritizes protecting the vulnerable rather than finding reasons to excuse the offender.
This video breaks down the shift toward codification, the new hard 40 cap on sentencing discounts, and the new aggravating factors, including penalties for exploiting youth or live streaming